When your case goes to trial, is there ever an instance where the judge may turn around and say, "Counselor, you are not permitted to talk about this particular topic"? Is that possible? Can the judge limit us, the attorneys who are bringing the case on behalf of an injured patient or an injured victim? Can he turn around and say, "This topic is off limits"? You want to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes, it is possible. It is possible that the judge may decide before trial that a particular topic is totally off limits and I cannot address it during the course of trial. Now, how would this come up? I'll tell you how it would come up. The defense, as we get close to trial, now asks the judge, either in a formal written request known as a motion or in person, in a conference, in chambers, and says, "Judge, Mr. Oginski and his client can't talk about the following things because," and now goes on to list a litany of reasons why I shouldn't be allowed to talk about a particular topic. And there could be endless reasons why I should not be allowed to talk about something. Likewise, there are instances where we will ask the judge to prevent the defense from bringing up certain things. Maybe they claim that my client caused her own injuries. And now we argue to the judge that this is a ridiculous argument. Here are the facts why it's impossible for them to raise that argument. Let's say she was under anesthesia, and now it's impossible for her to have caused or contributed to her own injuries. And if they try and raise that argument, the jury will look at them wondering, I don't understand, what's the problem here? Why are they raising that argument? So when an attorney asks the judge, either in formal written papers known as a motion, we call it a motion in limine, and no, it has nothing to do with lemons. This is a pretrial request for the judge to take action and to limit the issues that will occur during the course of trial. So yes, it is possible for one side or the other or both to argue to the judge that a certain topic should not be discussed. Now, you might be thinking an easy topic that shouldn't be discussed is whether somebody has been convicted of a crime in the past. Well, I'll tell you something, and you may not know this. If an injured patient or an injured victim was convicted of a crime in the past, and they did time for that particular crime, can I ask the judge to prevent that topic from coming up? The answer is no, I can't. Well, I shouldn't say that. I can ask the judge, but what the judge is going to say is, "Sorry, counselor, you're not going to win that argument." Why? Because the witness's credibility is everything here. And the jury is entitled to learn about this witness's past and whether or not he tried to conceal or hide or cover up the fact that 20 years ago he was convicted of a terrible crime and 20 years ago he spent 5 years in jail. The jury is entitled to hear that information because it focuses on his credibility. So if I were to try and raise that argument with the judge, he'd say, "Sorry, counselor, that's not going to work." The jury will be entitled to hear and listen and judge your client's credibility, and they can go ahead and listen to it and hear about it. What's another topic I might ask the judge not to have discussed? Well, maybe there's some irregularity with my client's tax returns, and now he's claiming lost earnings. And now I say, "Judge, that's got nothing to do with the key issues in this case, whether the doctor was careless, whether his careless caused my client harm and injury, and whether my client's injuries are significant or permanent." And you know what the judge would likely say? He said, "Counselor, you are absolutely right. Those things have nothing to do with the liability in this case, whether the doctor was careless. They have nothing to do with whether or not the doctor's carelessness was a cause of his injuries, and they have nothing to do with how permanent these injuries are. But," and here's the but, the judge would likely say, "they have everything to do with his credibility." So just like I talked about a moment ago, that my client's credibility is crucial, the same thing here. Any issue that comes up regarding whether or not my client is credible, whether he filled out a form that he shouldn't have been filling out, whether he filled out paperwork to obtain money, let's say workers' comp, he should not have gotten. All of those things raise credibility issues, and the jury would be allowed to consider and learn about that stuff to determine whether or not my client is believable and credible. Yes, it has nothing to do with the key issues in this case, but the defense would argue later on, once the jury is allowed to hear this, listen, If he lies about one little thing, how can you expect to believe him about all these claims he's making against this doctor? And that's the clear argument here. So let's get back to the question I raised in the title of this video. Can the judge prevent and prohibit us or the defense from talking about a particular topic? The answer is yes. Let me give you a quick example. So let's say a trip and fall occurred on a homeowner's property. Maybe there was some defect, a hole or something else sticking up that was a clear defect. And now, after the injury occurred, this homeowner went and fixed this problem. Okay, he fixed the problem because he realized now this is a problem. He doesn't want anybody else to get hurt, so he hires somebody, they come and fix it, and now by the time the case comes up for trial, it's all fixed. So now, we want to go ahead and introduce the fact that this guy fixed the problem, and the only reason he fixed the problem is because one existed to begin with. And had he fixed it before my client suffered the injury, this injury never would have occurred. And now the defense attorney turns to the judge before trial and say, Your Honor, we want you to go ahead and prevent Mr. Oginski from talking about what's known legally as a subsequent remedial repair. What does that mean in English? It means that this guy, this homeowner, this landowner, fixed the problem after my client suffered an injury. And you know what the judge would likely say? In fact, no, I'll tell you what the judge will say. The judge is going to say, yes, defense counsel, I agree with you. This topic is off limits. You, Mr. Oginski, and your client cannot talk about the fact that this particular defect that you are claiming to have existed was repaired. And that cannot be evidence of the fact that he knew about this condition and failed to timely fix it before your client suffered injury. Why? Because in these types of cases, known as trip and fall cases, we are not permitted to introduce evidence about any repairs that are made after the injury occurs as being evidence of the fact that the defect occurred, the defect was present prior to my client suffering an injury. In that instance, the defense attorney would be well within his right to ask the judge to prevent us from disclosing that information, and the judge would be totally correct to turn around and say, yes, defense counsel, you are right. Mr. Oginski, you cannot talk about any of these repairs that were made after your client's injury. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.